Thank you everyone for joining us for today's tech policy panel. My name is Sarah Van Pelt and I am your Wire Wheel host for this session. So before I introduce the moderator for this session, I'd like to cover a few housekeeping items. Please note that the views expressed here today by the speakers are their own and not the views of their organizations. And secondly, we hope that the sessions will be interactive, so please submit questions via the question and answer feature in Zoom at any time during the session. Please do not submit questions via the chat box. As we get our session kicked off, you should see the poll results on your screen, and I'd like to welcome you once again to our session today. I'm excited to introduce your moderator for today's session, Justin Antoni-Pillay, the founder and CEO of WireWheel. So Justin, I'll pass it over to you to introduce our panelists and begin the tech policy panel. I'll be back at the end of the session to wrap things up.
Sarah, thanks so much. And for folks who have been watching so far today, we've had, and yesterday, we've just had an incredible series of discussions. I have been involved in most of them so far, and luckily for everybody viewing, you get a break from me after this session. We have some terrific sessions that follow today, including our panel after this on ethical marketing, led by Camille Landau, an absolutely terrific panel, including the privacy leaders at Adobe, Deloitte, Shopify, and Stacy's colleague, Jules Polonetsky from the Future of Privacy Forum. We have a panel following that at 4 o'clock with the impact of privacy regulations on social media and retargeting, which is obviously a growingly important issue in our community. At 5 o'clock, we have a terrific panel on women in privacy, and led by Julie Gordon, with panelists from Donna Fraser from BBB National Programs, Susan Rohol from Warner Media, Teresa Truster-Falk from Blue Sky Privacy, and Susan Markell from WireWheel. And then, of course, at 6 o'clock tonight, Eastern, we'll have our closing keynote with Alistair McTaggart. So great discussions to come. And again, really grateful to have such phenomenal participation from our attendees in session so far today. And that brings us to our panel on tech policy and what will it look like in the next 4 years. We have an absolutely outstanding panel here today. And let me briefly introduce them. We're lucky to be able to represent so many different perspectives with our speakers today. Stacy Gray, Senior Counsel at the Future of Privacy Forum. FPF, obviously one of the leaders on a lot of different tech policy issues and privacy data protection issues. Stacy, welcome to the panel here today. Really looking forward to have you participate in the discussion.
Thanks, Justin.
Yeah. Stuart Verdery, CEO and founder of Monument Advocacy. Stuart also served in the Bush administration as one of the founding groups for the Department of Homeland Security, and served a number of important tech policy roles in the Bush administration, and then has been advocating and been involved in the tech policy community now for many years, more years than I will cite by number, Stuart. But great to have you here today.
Thank you.
And Alex Greenstein. Alex, great to see you. Alex, the director of the Privacy Shield program at the U.S. Department of Commerce. For those of us who are Privacy Shield companies, and on behalf of all of us, thanks, Alex, for all you've been doing here. You've had a nice, quiet year, I suspect, running the Privacy Shield program. Not much to do. It's been a nice, quiet job. Is that about right?
Yeah, no, easy. Yeah, 9 to 5.
Well, listen, I really appreciate you joining. As I mentioned a little bit earlier, we had a terrific discussion with Bruno Gencarelli from the European Commission earlier, your counterpart, Alex. So I'm really looking forward to picking up that discussion. And by the way, just one point before I open the discussion today, our last panel was with Julie Brill from Microsoft, Lindsay Finch from Salesforce, and Gabriela Fortuna from, who also is Stacey's colleague, jumped in for Bruno, who was in the middle of Brexit discussions. And I closed with 3 questions, Alex. One of those 3 questions was, will there be a new privacy shield in the next 6 months? And 3 out of 4 said yes. So we have a lot of faith in you, Alex. I won't tell you who didn't say yes, but a lot of faith coming up behind you. So we are going to come to Privacy Shield and some of the privacy legislation, but we want to start with some broader subjects. And on the cover of, or on the front page of most newspapers this morning, if there is such a thing as a newspaper, but on the cover of most of the sites, there was a discussion about the fact that President Trump has said that absent a withdrawal of the immunity provisions under Section 230 of the Communications Decency Act, there will be a veto of the defense bill, clearly elevating this issue around platform immunity. This has been a very big tech policy issue, both in the US and abroad. And Stuart, maybe I'll start with you today. For folks watching, there's a new administration coming in here in a couple of weeks. Platform immunity is a very significant policy issue, but would you mind just talking about what is Section 230? Why are so many folks paying attention to it? And we can kind of pick up the discussion from there.
Sure. And thanks again for having me. It's been great to watch your company grow, and congrats on putting on this conference. And I know it's been a good day, a lot of great speakers. 230, as you might imagine, it was a section of a larger bill about the internet passed in the mid-90s, and it basically gives internet providers and platforms immunity for hosting certain types of content. And it is really kind of the crux of our legal structure that allows people to post reviews on sites like Yelp or Amazon or other things and provide content, and gives companies protection from being sued for every type of content that a user might generate on the platform, so long as they comply with their self-identified rules. What's been interesting is that the president's critiques of 230 aren't really the ones that other people have been criticizing the law on over the last couple of years in an increasing matter. He's more worried about alleged social media bias, search engine bias, and those types of things. And so it's interesting because there is a growing belief that 230 at least should be modified, but the president's concerns really aren't the same ones as others that are, have looked at this a little more thoughtfully, both from Republican side and Democratic side. And I think the most interesting thing, I don't expect this defense ploy to work out. The defense bill has a ton of support. I expect it to pass. I expect it to them to override the president's veto if it gets that far, or to potentially pass it early next year once the president leaves. But the bigger question is the president's critique of 230 that it's that 230 is the reason that tech platforms are allegedly biased against conservatives. Is that going to stick after he leaves the presidency? And it may, if he's out there kind of bad-mouthing the law going forward. I'm hopeful, though, that more thoughtful legislators will look at 230 and say, yes, there can be tweaks, just like there were with SESTA, FOSTA a couple of years ago, and some of the other legislative proposals that have been out there. The idea of a wholesale repeal would just leave the internet totally unprotected for companies to do what they do that consumers like.
That's a great summary, Stuart. I have a couple of questions for you, but I want to make sure I can turn it over to Stacey and Alex. Any views, to the extent you have them, on 230? What's, any responses on what the current administration's perspective has been, and then what do you think is going to happen in the next 4 years under on this issue? By the way, part of what Stuart, I don't know if part of my reaction to even seeing the president's comments, it's a little ironic because I think a lot of the things that he's criticizing are actually protected by 230. In other words, absent 230's immunity for what shows up on the platforms, it might actually be much more difficult to get some of the unsupported kind of allegations up on the platforms at all. So it's not entirely clear to me right now why there's advocacy to take away the immunity given some of the priorities the president seems to have, even that remedy.
No, I think it's like, I don't like A and B like 230, therefore I don't like 230.
Yeah, it does sound a little bit like that, but maybe I'll turn it over to Stacy and Alex for any thoughts you have on this issue.
I agree. It's not particularly nuanced. I agree with Stuart too on the likely direction that this is going to take. So a wholesale repeal of Section 230 is just a total non-starter for Democrats and a non-starter for really anyone who's thinking critically about the issue. But we've seen a wide range of proposals introduced in the last 6 months or so that would create these sort of minor modifications or tweaks to the law in ways that might create room for political compromise. Most of them have been introduced by Republicans in the House and the Senate, of course, but interesting to note that it hasn't been a wholly Republican-led effort. Representatives Malinowski and Eshoo, for example, both Democratic representatives in the House, introduced Protecting Americans from Dangerous Algorithms Act, right? Modification to Section 230, but specifically for services that use algorithms to provide information to alter the delivery or the display of information, essentially social media news feeds, which is more in line with what Democrats tend to be concerned about, which is algorithmic fairness and social media. And similarly, we just saw an announcement today, I believe, from Representative Schakowsky, Jan Schakowsky, a Democrat from Illinois, who is the chair of the House Energy and Commerce Consumer Protection Subcommittee. So influential House Democratic leader, announcing she's going to formally introduce the bill that she circulated earlier this year, which is not a modification to Section 230 directly, but is a bill that would require social media companies and related other companies to issue terms of service around how they deal with this kind of content moderation, and then make any divergence from that enforceable. So yeah, I do see it being an issue that remains a major topic for the next couple of years.
Terrific, Stacy. And Alex, is this an area where you have any ability to comment? And again, we understand.
Yeah, no.
Sometimes
this is outside of my sort of mandate, can't comment, but definitely is sort of an issue to keep an eye on moving forward. And it's definitely active here, but also in Europe and elsewhere.
Totally get it, Alex. And we'll come back to you with some other points that I suspect you will be all over.
Yeah.
So maybe
Can I make one other point on
Stuart
230?
and
Move on.
I don't want to leave the subject. Let me ask this, and maybe Stuart, you can jump in. What is there's always criticisms of this in a broad way, like just on both sides on the platform immunity. What do you think is actually likely to happen in your view, either in this administration or on the next administration, in terms of either repealing, modifying, or changing it? Where do you see this going from Stuart, you and Stacy? What's the likelihood of even a modification in your view?
I think what's happened is, the Congress has been unwilling to challenge tech for many years. Basically, tech would come in with hypothetical problems, and Congress would say, "We don't want to mess with the goose here." That has changed in the last couple of years quite a bit as tech has become disfavored on lots of grounds. And now you see legislators and executive branch officials saying, "Look, we're willing to regulate and look at tech just the way we look at other areas of the law, telecom, energy, healthcare, whatever." And so I do think you'll see people weighing what type of content are we willing to regulate on the internet. We got that to that point with the Sesta Foster bill on exploitative issues. I think you'll see that with terrorist content. I think you'll see that with hate speech, potentially other criminal type of behavior. I think that's where the carve outs will come, and I do expect that those to gain traction next year. The Justice Department went down those roads in a couple realms with the bar Justice Department, and I think a Biden-led Justice Department is likely to continue that, at least in some respects.
Stacy?
Not much to add to that. If we do see modifications, I expect something that could actually happen might look something like, for example, modifications to the good faith provision that might require greater transparency.
Okay. Well, we'll close it up with this. I won't put Alex back on the spot. So Stuart and
Thanks.
Stacy, in the next year, will we see any modification to 230? And if so, what would that be in the next year?
Go ahead, Stacey.
I doubt it, Justin, but I'm not personally enough of an expert on 230 to really say, but I doubt it. And I would say much like privacy legislation, which I know we're going to talk about in a minute, it just wholly depends on whether Republicans retain control of the Senate or whether through the Georgia runoff elections, Democrats obtain a narrow lead in the Senate.
It's a great answer. Stuart?
If you gave me 2 years, that's the length of a Congress, and that's usually the way we think of how long it takes something to be legislated. I think 2 years, there will be small tweaks, probably on the terrorist content side, potentially on hate speech.
No, but now, come on now, Stuart. That was my question. So your answer is no on 1 year, yes on 2 years? Is that what you're saying?
Sticking with 2 years.
Okay. All right. We'll let you off with that one. All right. So now, obviously a big framing issue when you're talking about tech policy right now is that tech policy is not our biggest issue. It's not our biggest issue here in the United States. It's not our biggest issue around the world. We have so many folks suffering with either directly with COVID or with the fallout of COVID or economically. In our community here in Washington, so many small businesses, so many restaurants, so many parts of our community that have been just part of the fabric are closed or disappearing. And I think most of us are really hoping that the focus from a policy perspective and from the administration and from Congress and from everybody else will be on trying to tackle COVID and the economic effects on those who are suffering so much. That said, there are some pretty important tech policy issues that are around COVID, and privacy and data protection is obviously one of them. As a company that's looking to reopen, almost every time you consider it, there's some very big issues that you have to think about around the health of your team members, the health of your community. How do you appropriately track and make sure that you have a good sense of the health of folks before you open? How do you handle that data? And in the next 6 to 9 months, and I think probably all of us are getting really hopeful when you see planes flying around the country and around the world starting to delivering vaccines. I think these tech policy issues around privacy and data protection are going to be more and more important. So let's turn to the question of international data privacy, Alex, and then US data privacy. Alex, maybe we'll turn to you next. The Schrems decision in Europe has huge consequences to so many companies. And it's not, as you know, when you come to the movement of data from Europe to the US, which is really the way a lot of the international data transfer discussions are phrased, it can sound like a European problem, but it becomes a global problem really quickly. We saw company after company when I was serving in the Obama administration that might have some of their operations in Europe, but say, for example, their warranty or their safety units might be in other parts of the world. So you can't just say any company, even a European company, is thinking of it as Europe data or US data. Obviously, it was a huge blow when you saw Privacy Shield struck down almost exclusively based on these national security issues that aren't really within the control of companies all around the world, right? It's not like companies have any choice about when they have to respond to a request from the federal government. Would you mind giving us a little bit of an update on where things stand on the Privacy Shield discussions or on the Schrems discussions to the extent you can? Are you hopeful that we're going to get a new Privacy Shield here in the next few months? To the extent you can talk about that, and how do companies start to imagine the transition now to a new administration and what's coming next?
Yeah, no, certainly. Thank you very much for the question, and I think you make a very good point that sort of the current sort of coronavirus issue sort of makes this all the more salient. And also just sort of the economic impacts of that sort of put a premium on letting companies sort of continue to do business and sort of creating the environment that facilitates that. And also, I mean, that's also a very good point that with globalization, sort of companies need to be able to move data around the world. And it's really indispensable to sort of how companies operate these days. Basically, this is sort of a key underpinning of the $7.1 trillion transatlantic relationship. And then when you think about data transfers globally, it's even more important. And then also, I mean, with Privacy Shield, so many of the companies who depended upon it were small and medium enterprises. 70% of our participants were. And that really does make the difference in them being able to continue to grow their businesses and do business internationally and access other markets. So we're definitely sort of aware of that and sort of the impacts of the Schrems 2 case on both Privacy Shield and sort of on the EU standard contractual clauses and the impacts that had on businesses. And so we have a very strong partnership with the Commission on this issue. And I think sort of as you saw with like, Bruno's remarks earlier, we're definitely both committed to working this through, and we're engaged in sort of ongoing discussions that are getting more and more intense and concrete about developing an enhanced Privacy Shield framework. And I think you sort of can go back to sort of the joint statement back in August between Secretary Ross and EU Commissioner for Justice Renders, I mean, indicating that we both recognize that this is extremely an important issue and that we need to work to address this in sort of a government to government fashion, because as you noted, these are national security issues. And they're also issues that we have a good deal of experience working together on. We address these issues in terms of Privacy Shield, and we've continued to have sort of ongoing discussions about them. I mean, 3 annual reviews of the Privacy Shield framework has really built up a good common knowledge and understanding around this issue between the Commission and the United States. And I think on that basis, we are moving forward with sort of more intensive discussions about what enhancements we can make to the framework in order to address the court's concerns. And just sort of like, as a final point, I think it's important to note that we and sort of the European Union are really on the same page here. I mean, we see eye to eye in terms of the importance of privacy and limitations on sort of government access. And as Bruno noted, I mean, we're working together in multilateral fora on this, such as at the OECD. And this is something really where there is sort of a need for a broader sort of discussion amongst countries about sort of the appropriate limitations on government access to data. And I think this is sort of happening, but it's also important to note that sort of we and sort of the EU are like-minded on this, and that we are working together to I can't give a guarantee on sort of like the time frame, but we're definitely working to sort of find a solution to this.
As I said, Alex, I mean, we're really grateful for what you're doing. It is a hard thing you're tackling. But a lot of the companies, as I mentioned, that are actually affected by the Privacy Shield decision are the smaller growing companies, because larger companies often had binding corporate rules, standard contractual clauses, and obviously a lot of ways that they could pivot. So my sense of it, having worked with a lot of companies, and I suspect Stuart, Stacey, you could weigh in too, that the ones that have had the hardest consequence on both sides of the Atlantic are probably smaller companies that were trying to do the right thing. In other words, had put a lot of commercial protections in place for consumer data and are exposed as a result of some of the national security items that were raised in Schrems too. So it's very heartening to hear that there's so much work going on the issue. Here's one question, and then maybe I'll turn it back to Stuart and Stacey. For you, Alex, we are in a transition. You served in roles at the State Department during the Obama administration, and in other roles. Now you're in a role at the Commerce Department. You're going to be going through a transition between administrations. There's rules of engagement that the European Commission has around engaging even with the US government in a transitional phase. Bruno was highlighting that this is one of those issues that is urgent enough that there seems like there could be some good progress made. But could you give our listeners a little bit of a sense of how is this transitional phase going to affect the discussions, if you can, between Europe and the United States around Privacy Shield? And if you have any ability to comment, where do you see it changing here in the next couple of months, like process-wise, even if you can't comment on policy?
Yeah, I guess I would say that sort of like, I think there's a great deal of continuity on this issue. And certainly, I mean, I think sort of data privacy and national security have been quite there's been a great deal of continuity sort of like on our approaches there. And we are continuing to sort of move ahead on sort of working this issue with the commission right now. And I would say that sort of we have a strong team here. Like, many of the people who are involved in this are veterans of the previous Privacy Shield negotiation. And we've been working on these issues for a number of years with the same people in the commission who know these issues quite well. And so I think that there is sort of a strong basis for continuing to move forward and make progress. And also, I just sort of go back to the fact that, yeah, I mean, this issue is quite economically important and also sort of important to sort of the transatlantic relationship. And so I think given sort of the stakes here, it's important that we continue to make progress and move forward on it, because the other issue is sort of, certainly this impacts Privacy Shield in the first instance, but it also does sort of have associated impacts on companies using the standard contractual clauses, and certainly following the EDPB's draft recommendations, that has brought up some questions around sort of the durability of the SCCs and other transfer mechanisms. And so that's why it's important that we do our sort of homework and address sort of the national security issues in sort of a government to government fashion through Privacy Shield. And sort of our anticipation there is that sort of what we negotiate in that area would also cover the other transfer mechanisms. And so I think that's the kind of, this is, yeah, too important to sort of let it fall by the wayside.
Yeah, no doubt about that. So, and maybe I'm going to come back to some questions. Let me just say, for everybody watching or listening, this is a good chance for you to post some questions to the Q&A, and we and the panelists can kind of bring them up. So I'm going to ask a few in a minute here, Alex, but maybe I'll go to Stuart and Stacy. Obviously for both of you, you're probably watching civil society, the business community, companies dealing with the fallout of Schrems. I probably have an ability to speak a little bit of like, what do you see happening in the change of administrations on this issue? Stacy and Stuart, on Privacy Shield and these issues around international data transfers, what do you see changing from your perspective between the current administration and the incoming Biden administration, if at all?
I guess, I tend to think of these cross-Atlantic issues as kind of just generally slow moving at all times, just because the commission is so bureaucratic. And I think that they will probably have generally a better view towards what a incoming Biden administration looks like, just from a macro political standpoint, in terms of all kinds of other foreign policy issues, climate change and all kinds of other things. I would say that you mentioned small businesses certainly are nervous about this. Like, large businesses are as well. They've invested heavily in this regime, and to have it kind of in jeopardy is a little bit nerve wracking. We've been, I think, very happy with the U.S. government's, work with the EU. Most of it is career, as we know, but there will be new politicals coming in here soon at state, at justice, at commerce, and other places. And we know that they've got to kind of continue to lean on the Europeans to find common ground. I remember when I was at Homeland, I had to testify in front of the European Parliament on airline data issues, which was kind of a precursor to Privacy Shield. And that was nerve wracking. And that was just a tiny little slice of the economy, not much the whole thing that is kind of up in the air right now.
Yeah, and I would hope to see a Biden administration be a little more engaged and committed to this. And I'll just underscore the importance. Yeah, I agree, not just for small and medium businesses. So before Schrems 2 came out, FPF did a study of the types of businesses that were relying on the Privacy Shield agreement, published the results of that study back in July and found that 5,400 companies had signed up for Privacy Shield in total, more than 1,000 just in the last year. And interestingly, nearly a third of the total number that we analyzed had joined Privacy Shield just to transfer human resources data. So we're talking not just leading technology firms, but also most major employers are thinking about this.
I think that's a great point, Stacy and Stuart. And maybe then I'll ask one or two questions that have come up just from our audience today. Alex, these are not shockingly directed a little bit more to you than to me.
Sure.
For example, what can industry do to support your efforts in getting another new Privacy Shield? And there's an interesting issue that Bruno talked about too, which is one way or another, UK is leaving the European Union, and one way or another, that probably means we're going to be dealing with trying to make sure that there's a transfer method between the US and the UK, which has its own version of essentially GDPR. So could you give us your views on whether Privacy Shield is likely to form the basis of that UK-US transfer agreement, or if there have been any discussions on that? So maybe two questions for you. What can we do to help, and how do the discussions go with UK on a data transfer agreement?
Yeah, no, I think that's certainly we really appreciate the support that industry has given to Privacy Shield and transatlantic data transfers more broadly. And I think that certainly continuing to stay focused on this and focusing on awareness raising that this is an issue that requires attention is helpful. And also I would reinforce the point there that Stacey made about the fact that human resources data really is a key element of this. And also that Privacy Shield isn't just about US companies and US business in Europe. It also is a key enabler for US companies who employ people in Europe. And that's something as well. And there's also large European companies who need to be able to move HR data to the United States and support their multinational operations. And so that's kind of why I tend to think about Privacy Shield and these data transfers more broadly, as it's not just about customer facing services. It's more like an enabler of the entire transatlantic relationship, because if you want to operate a factory, if you want to do investments, you need to be able to move data around. And so that's why we're very much focused on getting this right. In terms of the UK, we definitely have a good relationship there and have ongoing dialogue with the UK on these issues. I mean, we're tracking, their discussions with the Commission, and certainly are looking at what the data transfer environment will look like. Under various scenarios. We provided some guidance on this previously, but I think a lot of it is we're still involved in discussions about.
Yep. And broadly speaking, Alex, over the next couple of years, you're going to see so many US companies subject to CPRA anyway. CPRA has a huge amount of overlap with GDPR. You're talking about, for the first time, so many US companies who have not had that internal requirement to capture assessments, to document them in the way that you had to do in Europe, are now going to have those requirements under the CPRA. In some ways, you may ending up with convergence as a result of just the California law, which just covers so many US companies. And that may make it a lot easier for a lot of the discussions, I think, that were a bigger challenge before. So let me put one question. I won't put this one to you, Alex, but I'll put it to Stuart and Stacy. Answer if you feel like you can.
Sure.
Stuart, Stacy, will we have a new Privacy Shield in the next 6 months?
Stacy, you want to go first?
Oh, I can't begin to answer that one.
Oh, come on. Nobody's going to hold you to it. Okay, I won't make you answer.
6 months seems a little aggressive. That doesn't strike me as like European time.
That's pretty fast.
I have more faith than Alex. I'm saying yes. Yes on a new Privacy Shield in the next 6 months. Alex, if you feel like you can comment on anything, do.
I mean, no promises, but we're definitely working this, and we want to get to a resolution as quickly as possible, because yeah, this is sort of an issue that we don't want to sort of drag on.
Awesome. Okay, well, let's go on to, as usual, we're going to be running out of time. We only have 10 minutes left. And the third subject that we talked about a little bit in setting this up is, because this is more about broad tech policy, antitrust in this transition phase, certainly into the new administration. So here's my question for the panel. By the way, part of the reason we focus on this issue of antitrust in a data privacy context is so many of the lawsuits that are going on or contemplated here or in Europe are around the idea of data monopolies. In some ways, they're very closely related to the amount of data that some of the largest platforms have around people and their ability to tie different services to that core amount of data. So there's in many of the places around the world, there's a pretty close relationship between privacy law and antitrust law. So here's, again, for anybody on the panel, obviously there's been at least one lawsuit filed here, including with a lot of states' attorneys general against Google. There's been a fair amount of coverage about potential lawsuits against Facebook. There's almost always some discussion around similar kind of approaches in Europe on antitrust. So my question for the panel is, where does this go? Where do these antitrust theories go in the new administration with President-elect Biden's team coming in? This antitrust is often one of those issues that's not quite so clear to call, on a Republican versus Democratic basis. But for any of you, where do you see the antitrust sort of approach progressing in the next 4 years?
Sure. I mean, I'll jump in. I mean, passing antitrust legislation is really, really hard. And that's why you see 99% of the quote law in this area is either court generated or via consent decrees. The key thing though is, as you mentioned, is an activist DOJ or an FTC can make a huge difference, either in terms of rulemakings, in terms of actions, in terms of mergers, in terms of oversight. And so I think you'll see a Biden administration really lean there, where they're doing their own thing on each of those areas, as opposed to kind of relying on Congress to pass something, because antitrust law doesn't just touch tech; it touches all sectors of the economy. Democrats will be split. Do they want to go after tech, or do they want to go after kind of all big business, which they tend not to like? So I'll go ahead and predict that there will be an antitrust legal change via Congress, but that won't be till 2025.
Stacey, Alex, do you feel comfortable talking about this?
I think that's a pretty wise assessment. We might still continue to see state AGs sort of charting their own path on this issue. But I would hope that there's more of a divergence towards the need for federal privacy legislation. And I think what I see with a lot of legislators, particularly state legislators, is that these two very different issues, which are privacy and antitrust, get conflated around just the need to do something about tech, to do something about data collection. And that would probably be best channeled into a comprehensive federal data protection law.
Justin, I should also mention, I mean, one key thing here is, many smaller tech companies are designed to be bought. They're not designed to go to become the next billion-dollar company. And so that'll be a really interesting thing is for the venture capital community, the investor community. Where are they? Are they going to tell a Biden administration, no, actually we like companies that can be acquired and kind of have a corporate parent that can help them grow? Because that's where most of the problems have been, or perceived problems, is people buying nascent competitors, nascent upstarts, and then growing them. But that's been great for the investors. And so where's the investment community that probably will have a decent voice in the Biden administration? What are they telling the antitrust police about acquisitions?
Yeah, it's interesting. Well, a lot of the theories right now that are captured, and then I'll turn to Alex, are actually somewhat tying theories, Stuart. They're around offering different services and tying them to one another within a platform. And I get what you're saying. You're saying they acquired related services or acquired related companies and then offer one service as part of an overall package or require it to be offered. But I do think I agree with you that maybe it may not be legislative, but I'm, over the next 4 years, I suspect there will be quite a different view from the enforcement perspective, from the new administration. But with that, maybe I'll turn it back to Alex if you're able to comment.
Yeah, no, I mean, just sort of a generic comment here. I mean, but definitely want to sort of echo Stacy's, comment about disaggregating sort of the discussions around sort of antitrust and sort of privacy. And I guess it always comes back to sort of me is like my background is in economics. I mean, it's sort of focusing on sort of the negative externalities the things that you don't like about sort of policy outcomes and sort of trying to address that. I mean, if there are privacy problems, then it does seem like privacy legislation is sort of the appropriate vehicle for that. And then sort of, I mean, competition and sort of the marketplace structure is sort of something of a separate question. But again, that sort of is a little bit out of my area of responsibility, thankfully.
Well, no, and again, Alex, I appreciate you commenting like that. We are down to the last few minutes of our session, and I, again, knew we'd run out of time. So let me ask two questions. You can either answer both or answer one or answer neither or close in whatever way you feel comfortable. So how about that for optionality?
Sure.
Here are my two questions. One, there's a pretty big set of discussions in the policy community around what will be the difference in your view between President-elect Biden's incoming term and the last term of the Obama administration from a tech policy perspective? Is it going to be a continuation of President Obama's second term? Or if you think it's going to diverge in some way, where do you think it will be different in any way? And then, of course, we're at a privacy conference, so I have to ask each of you, will there be some kind of national privacy law in the next 3 years, comprehensive, sort of not just COVID-based? What's your view on that? And if I put that kind of a time frame on it?
Well, I guess from my perspective, again, this is sort of as my personal viewpoint, not in any official capacity. I mean, I think that certainly it's a different time and sort of a different place, and a lot has happened sort of since the Obama administration. And I think that certainly a future administration will need to sort of approach the challenges that we're facing today. So things will be different and will require perhaps different approaches, but that's life. And then in terms of privacy legislation, I guess I'll say that I personally think that sort of would be good, and I hope that the privacy legislation does pass, but that won't necessarily fix our problems with regards to Privacy Shield, which I remain focused on, because that's a national security issue.
Yep, totally get it. That makes sense. Stuart, Stacy, what do you think on the two questions?
I'll answer your second question. So as to whether we will see federal comprehensive privacy legislation in the next 3 years, confidently, yes, absolutely. And the reason for that is I think the enactment of CPRA through Californians voting on Prop 24 creates a major window of opportunity for those next 3 years that's going to further the motivation to have a federal law that preempts some number of state laws. So the law comes into effect in 2023 in California. It would require pretty significant investment in legal interpretation and technical compliance. And if there's an opportunity to get ahead of it through a preemptive national law, I think the business community will be incentivized to support that. So there's your window of opportunity from California, but then also I think the chances are it's almost inevitable at this point that additional states will pass comprehensive privacy laws in the next few years, because we saw such a groundswell of state legislation that was just heating up before the pandemic sort of paused everything but COVID-19 legislation. And I would expect that to return in full force in 2021. So as soon as we see state laws that create certainly any kind of conflict or major concern for the business community, like a private right of action or major inconsistencies between states, I think that creates an additional incentive. So the stars are all aligned. I think it's a strong bet that we'll see a comprehensive law.
Thanks, Stacey. Stuart?
Picking up on Stacy, having lobbied for companies trying to get Congress to move, we have not been successful in convincing them to do so with hypothetical concerns about conflict of state laws. I think it's only when there's actually a conflict of state laws that they are going to be willing to kind of jump in and Bigfoot the states. That being said, I think there is a chance a bill could pass if you ever have real negotiations between state AGs and the kind of their Democratic defenders and the business community and the Republican defenders on what type of preemption is really needed. I think there is a way to get that done, and I expect that over again a 2-year period, I think a bill could be passed, but it's probably only once there's a conflict of laws, and that depends on how fast a state or states act. On your other question, real fast, I think the worm has turned a little bit. I think the second Obama administration is very tech friendly. You know, a lot of folks who came in from tech into the Obama administration. The Biden land is going to be controlled much more by populists, by labor unions, I think less by kind of tech folks, to be honest. So I think it'll be a tougher regime than you had 4 years ago. That being said, I think tech's response to the pandemic has largely been praised in terms of giving people content they want, in terms of helping with broadband and those types of things. So we'll see. I think it'll probably be less confrontational than the last 4 years for sure, but not nearly as kumbaya as the last Obama term. I mean, maybe when you were there, Justin, things were great for tech, but I think unless you're going back in, I think it may be a tougher road to hoe.
Well, I am not going back in, but I do hear what you're saying. I look, we're excited about a lot of the developments that are happening, and listening to Julie Brill, for example, who's been, obviously quite involved on Washington. I think there's a lot of confidence on another couple of state laws passing in the next year. I think Washington has a really high likelihood. I think there are a few others. I'm interested in the preemption point because to date, most of the California delegation has been pretty clear that they won't vote in favor of something that preempts and doesn't have at least equal protections to what's in CCPA. I don't know if that'll carry to CPRA, but that's always seemed to me to be a challenge with respect to preemption. And when I've watched the discussions around Washington, for example, it looked like private right of action has been the blocker to getting something like that passed. So maybe I end up with a little bit of what all three of you said, which is I'm hopeful that we'll get a national privacy law. I do think Stacy's points and your point, Alex, on progress here and actual conflict may be critical. But when you watch CPRA, which had a lot of the core protections in GDPR, be opposed by all of the normal civil society groups, you do see that it's going to be a complex road to get there, one way or another. But either way, I knew we would run out of time. This has been an absolutely terrific discussion. Alex, Stuart, Stacy, thank you very much for joining us here at Spokes. Our core mission around Spokes has really been to get information out, democratize the best knowledge on privacy, data protection policy, and make it available to the community. And this session has been just great in terms of getting information out and really contributing to that. I'm really grateful that all three of you have been willing to take some time with us today, and I hope you'll join us again on our next one.
Thanks so much
for having me.
Yep. Thank you all.
Cheers.
So that concludes the session. Thank you all again for joining us. I'd like to remind everyone that the recordings of this and all of the other Spoke sessions will be available after the conference concludes. On your screen, you should see the agenda for the rest of the day. The next session is Ethical Marketing, How to Establish and Retain Consumer Trust, which will begin at 3 p.m. We hope to see you there and have a great rest of your day.
Thanks, everybody.